All righty. Good morning, everyone. This is the sixth in a series of hearings and roundtable discussions, which the subcommittee continues to examine the issues and solutions surrounding the regulatory state. Today, we'll hear from witnesses representing USDA, Labor, Interior, and the EPA about their agency's retrospective review programs, their progress in reviewing existing regulations, and the challenges they've encountered. The next steps, where do we go from here? Every president since President Carter has urged agencies to initiate a retrospective review or a look back of their existing regulations. In 2011, President Obama issued Executive Order 13563. Executive Order 13563 directs agencies to develop and submit to OMB, Office of Information Regulatory Affairs, a plan for periodic review of existing significant regulations to determine whether they should be modified, streamlined, expanded, or repealed. In 2012, Executive Order 13610 urged agencies to take actions to institutionalize regular assessment of significant regulations. However, experts have questioned how rigorous or effective these efforts have been. Retrospective review of regulation is important. Changing circumstances and technological improvements may render some regulations outdated and ineffective. Initial agency estimates of potential costs and benefits of an action can prove incorrect. Therefore, we must ensure that agencies undertake retrospective reviews of current regulations so we know they continue to serve the American people consistently and they reflect the least burdensome option to achieve their desired result. Because retrospective review of regulations is so important, in July, Ranking Member Heitkamp and myself proposed legislation to ensure that agencies plan for retrospective reviews from the outset. Senate Bill 1817, the Smarter Regulations Through Advanced Planning and Review Act, requires agencies promulgating major rules to commit to a time frame to review the regulation, a plan for that review, and the information they will collect to facilitate that review. This is just one of the bipartisan common sense proposals that Senator Heitkamp and I proposed in July to improve the regulatory process to make it more accountable to the American people. All three proposals recently passed through committee with wide support. Although we hope to strengthen retrospective reviews in the future, today we're here to discuss the current retrospective review effort and the progress agencies have made. We look forward to hearing from agency officials about their experiences and what else we can do to help facilitate these very, very important reviews. I appreciate our witnesses' written statements and their oral testimony that's coming in just a moment. With that, I recognize Senator Heitkamp for her opening statement.
Thank you, Chairman.
Let me bounce a couple of different questions just to set the stage for some of the conversation as well. Do any of you know how many rules your agency has total on the books? We're not going to get into guidance. I would tell you that Senator Heitkamp and I have strong opinions about guidance side of things, but let's talk about just the rules that are listed as rules. Does anyone know how many that you have in your agency?
I don't know the answer to that question.
Yeah, I don't know. It would be looking at our congressional federal, the Code of Federal Regulations, and when they go, I used to be able to keep them on my bookshelf, but now it's all electronic, so you can't quite get the visual.
Now you'd have to have a larger bookshelf as part of the problem as well. So yeah, okay.
I do not have a number to provide you.
Okay. Sixton.
I cannot provide a number at this time.
Okay, well, it's not trying to be a gotcha question. It's a lot. For the only one that I actually pulled on it was labor. Bless you for that. Sorry, but 676 rules is what the number that I pulled on that. And the reason I tried to pull to get a perspective is because when you talk about reviewing 14 of 676, it begs the question of how do you select it? Because y'all are going through filters. All of you described a filtering process, talking to staff, electronic methods of actually getting input into it, town hall meetings, interacting with people, Federal Register announcements, all of those things. Secretary Perez and I talked at length about Federal Register announcements and such months ago. The challenge is if you have 676 rules and 14 of them have gone through a review process over the last several years, to go through the rules that are out there will take approximately 125 years or so. So obviously the goal is not to review every one every time. But Ms. Klein, you mentioned, I think at one point you said it was the goal to try to get at least one new one a year to be able to get it out there and to be able to get going. That was the minimum standard. The challenge is if there's only going to be 1 to 5 to 10 that happen in a year, it's extremely important there's a good filtering process to know which ones are chosen because that means there are many that do need to be addressed that are not. So my question is, I know there was this large gathering filter on it. I want to ask about the final decision phase. In your agencies, how is the final decision made? You've got all of this data that's been gathered from town hall meetings, from electronics, from conversations in the agency. how is the final decision made in your agency on which one will actually go through the laborious process of retrospective review? So I can start in whatever order. Ms. Klein, you can take that first if you'd like to.
Sure, thank you for that. We collect information from each of our bureaus and offices about what they want to put forward for retrospective review. And it does go through a process where our Office of Executive Secretariat, which largely helps, they're like the traffic cops of regulations within our agency and help move the papers around. And they bring those forward to the Deputy Secretary's office and the Secretary's office. And then we engage in a process with OIRA to determine what's identified. I've always felt that we identify things for retrospective review, but there are a number of actions that we might be engaged in that aren't identified as retrospective review, but really when you look at them could be identified in that way. But our bureaus and our staff, I mean, part of our challenge with retrospective review is really getting people to think about it in their day-to-day business and really tell a better story about what they are doing in their day-to-day work, and that what they are doing, improving and modernizing our regulations is part of retrospective review, and we don't always do a very good job.
There should be comment on that. So just clarification then. Secretary, Deputy Secretary, and OIRA, when the final decision is made, that's the conversation point once all the data is there, collected, and go through a process. Is it a series of meetings, single meeting? And you don't have to give me the details of all of them. I'm just trying to get a feel for that final decision once it gets made.
Well, we have a semi-annual reporting requirement to OIRA, so we provide reports twice a year. And so those meetings happen throughout where a regulation might come up and we're alerted to it. We actually meet with the Office of Executive Secretariat every day. And so it happens during the course of conversations. I can't say that it's how many meetings.
So it's an ongoing process. Okay, all right, thank you. Mr. Zarin.
Well, at USDA, the #1 priority is implementing the Farm Bill. So since 2014, that's been our #1 focus, get that bill implemented rapidly and effectively. And as the Secretary testified, we've pretty much done that. We're nearing the end of that implementation phase. For other actions,
you have to hurry and implement it before Congress changes it midstream. That's probably
well, that's rigorous oversight. But the department every year has a top-to-bottom regulatory review of the regs that the agencies are proposing to do. We do that twice a year, consistent with the publication of the regulatory agenda. The number of criteria we...
So who sets the regulatory agenda? How does that...
This is the way USDA has a strategy is to have robust senior level involvement. So it is managed out of the Office of the Secretary. So the Office of the Secretary will put out a call for like, what are the key regulations you want to accomplish?
Yeah, go ahead. Yeah, go ahead.
A call to who? To senior
the missionaries staff? And then to the agencies. And then we identify, then they respond what their regulatory ambitions are based on their involvement with their stakeholders and what their legislative requirements are in that. So we review that twice a year, and we come up, as part of that process, it's determining what the regulatory priorities are for the department.
Okay. That includes what will be reviewed. So it's setting the regulatory agenda for new regulations and examination, but it also includes the review in that.
Of old regulations as well.
Okay.
That is presented to the Office of Management and Budget, and we review that with them to determine if this is consistent with the administration priorities.
Is OIRA involved in that as well?
Yes.
Or does this go straight to OMB?
OIRA, it goes to OIRA.
Okay, got it.
And we meet regularly with them to establish what the regulatory priorities of the department should be consistent with administration guidelines and priorities.
Okay, then final decision, let's say you've got 50 things in the bucket at that point, and you determine we've only got the bandwidth to be able to do 5 of these. Where's that final decision made?
With the Secretary of Agriculture.
Okay, all right, fair enough, thank you. Ms. Zell.
So at the Department of Labor, we take great care to ensure that we're having, I think, robust ongoing conversations with our agency heads, our deputy secretary, and our secretary about the regulatory actions of the department. We don't separate out in those discussions retrospective review from non-retrospective review regulations because the workload and to develop those initiatives comes from the same pool of staff.
Which is how many staff? Help me understand the context of that.
There's regulatory experts and leads in each of our enforcement agencies or our regulating agencies. So I can't give you a number of how many people work on regulations in each one of our agencies,
Okay.
But that each agency within the Department of Labor has a head of standards or a regulatory division, and then they have.
They're both
key
promulgating the
experts.
new and working through that and also reviewing the old.
Yes, because the expertise that's needed to do that is very similar in
Sure.
nature. So you're drawing from the same talent pool. Our regulatory leads in each of our agencies compose a regulatory council, so that across our department, our regulatory experts are working with one another constantly to share best practices. And that's something we coordinate through our Office of Policy, which is a very helpful coordinating function. We have ongoing dialogue between our agency heads and the Office of the Secretary about what the priorities are, what they should be, what information the Secretary and the Deputy Secretary are hearing from stakeholders, what our Office of Public Engagement is hearing from stakeholders, what the agency heads are hearing from stakeholders and their staff. And so when I say the Department of Labor really emphasizes the input that we're getting from our employees, it's because in many instances, it's our employees across the country who are engaging frontline with the stakeholders, and they know now that they have a feedback loop, a way they can share what they're hearing back to their agency heads. So our agency heads, working through their regulatory experts, will develop priorities, and those priorities have to be informed by not only what resources they have available, but what's statutorily required, what's court mandated, and I think that has to drive a lot of our decision making. And you balance that against the list of the priorities for the for the department, the priorities for the secretary, the priorities for the administration, and in that, constantly included in that, is a how are we addressing what may already be out there? How are we taking advantage of the commitment and driving forward the commitment to retrospective review? So it's not a separate conversation that's had. It's an integral part of the conversation. That's one of the things we're doing to drive the culture.
So final decision is made where and how? All of this is gathered, all this input?
All of it's gathered, all of the input is available. Final decisions inside of the department lie with the Office of the Secretary in partnership with the agency heads. That's transmitted to OARA and OMB. And we have robust conversations with them to ensure that we're not conflicting with the work that the other agencies are doing.
Okay. Thank you. Mr. Nickerson.
I think one thing I want to emphasize is that a lot of the EPA's rules are on a regular schedule for review based on statute.
Yours is a little bit different, obviously. They're statutory required, and that's part of the reason that we wanted EPA to be here, because you've lived in a world where there's a requirement to do reviews in certain cycles.
So in most cases, those are not called out as part of our plan. So let me talk specifically to the plan. Once we get all of the feedback from our stakeholders and from within the agency and from other federal agencies, that collection of suggestions is given to the appropriate programmatic office at EPA for input by their own experts. And then that is considered in addition to the agency's priorities, the principles of the executive order, and the availability of resources to prioritize which things would be part of the retrospective review.
Okay, so let me ask a process question on that, because that's a great issue that all agencies have, is the availability of resources. You're dealing with both manpower and dollars to be able to do it in the investment. When you have to make the decision, I guess the concern that I have, and I want to put Senator Heitkamp in this as well, is at some point an agency says, this really needs to be reviewed, and I know it's costly on the economy, but it's really expensive to review this particular one, and so we'll wait to review that one because it's costly on us, knowing that it is an issue that needs to be addressed because your employees are all screaming at you, hey, I get this on the phone all the time, people are sick of this. How do you balance the two of those, where we're tough on dollars to be able to do it, but we know this has a negative effect, making a decision, we can only do 5. Best case scenario, we'd really do 15, but these other 10 we don't have the dollars for.
It is true in our case as well that many of the staff who are doing the work on retrospective review are also doing new regulations that we're obligated for various reasons to undertake. I think that balancing takes place initially within the program office, but eventually up at the agency senior leadership, and then those final suggestions are also discussed with OIRA, as some of my panel members have mentioned.
Okay. So it's senior leadership has to make the decision where they're going to invest budget dollars and how that's going to work at that point.
That's right.
Okay. Well, it's totally different off subject, but you might want to pass on the renewable fuel standard still hanging out there to be able to get that. That's off subject. That's for free. You can just pass that on. We won't bring it up. Let me ask just one question, Mrs. Klein, you brought up as well in this, and we can jump in at any time here, Senator Heitkamp. One of the things that you mentioned was the right-of-way on Indian land that you cited. That's one of the areas that we had pulled on before, as you had referenced. That's one. It's a recent one. It's been redone. That was promulgated in 1968. As far as we can tell, this was the first review of that since 1968. Well, since I was born in 68, I can tell you I know exactly how long ago that was. That's a while to wait on a regulation. Why did that sit out there for 47 years? And what spurred it now? I mean, the right-of-way issues have been around for a long time. We've obviously had telephone and power lines and everything else. In Indian country, this has been an issue for a while. What brought this to the top, and what can we learn from that?
Thank you. I'm not sure I can speak to why it has taken
Yeah, you don't have
so
to take
long.
blame for the previous 40 years. I get that too. I'm just trying to figure out what brought it to the top
Certainly between
now.
68 and 75, I can't speak to. But what spurred it on was really the administration and the Secretary's commitment to improve how we are regulating Indian country. We heard loud and clear, and in terms of, the intersection between people screaming at us and telling us that things are not working, and what our core mission and priorities are, the improving regulations for Indian country is that intersection.
Right, but I'm trying to see what brought it up and how this gets addressed and what we can learn from it. Was it a pure volume? Was it the number of people that were expressing it? Or was it the length of time? Because what we're trying to determine is some of these things take a long time for review, and we're going to talk about the mechanical press issue that was a good success, actually, to be able to review as well with OSHA. But it's the same issue. It's taken a while to be able to get there, and what we can kind of learn on this side of the dais on trying to help the agencies in this to say things can't sit out there this long that we know have been a problem for this long. Does that make sense? So I'm looking for the triggering devices and things that we can learn from it to say this pushed it over the edge.
Right, and as to the rights-of-way regulation in particular, we've had a emphasis on how can we provide Indian country with more power over their own lands. And so the rights-of-way regulation, like the Hearth Act leasing regulations before that earlier in this administration, the housing improvement program rules that I also referred to, these are all part of a very concerted effort on our part to try and shift some of the responsibility and governance to tribes so that they can start governing what is happening on their own land.
There's a philosophical change within the leadership of Interior to say this is important to us, so the selection was made, we need to address this.
Yes.
Based on, because like I said, it's been years, this has been an issue, but there was philosophically the top saying we got to readdress this.
I would suggest that there has been a philosophical change in how we approach Indian country.
All right, Mr. Zell, let me ask you as well about the mechanical power press rule, because again, that's one that's been talked about for quite a while as well, the paperwork requirement on that. What brought that to the top to finally say this has to be addressed now?
I think for us there was, including from the front office and the office of the Secretary through the agency heads, truly an increased emphasis on trying to hear what our enforcement officials and our employees in the field were telling us. And when in 2011, when we did a very robust engagement that involved and included our employees, and that came back, there were questions raised with the agency about, you're hearing this from the employees, is there something we can do? And I think that through that dialogue and through the emphasis on employee engagement and our robust efforts to drive kind of a greater culture change within the department and increase the emphasis on retrospective review, it became clear to us that that was something that there was not a reason to proceed with.
Okay.
That
If a rule like this, when it was first promulgated, had a deadline to say, at some point, we have to review this again. I don't mean a deadline to go away, but I mean a deadline that at that spot, we need to review it. And so there's just normal rotating calendar. Would that have helped? Department of Transportation, for instance, has that already. Every 10 years, those rules have to come back up again, and someone has to look at it. So it can't sit out there for 47 years or for a long time and say this just have to rise to the top. EPA deals with that all the time. I can assure you if EPA misses a deadline, there's a whole team of lawyers hovering around EPA ready to file suit on them to try to compel that. Is that a help or is that a hindrance to the agency to be able to have some sort of deadline sitting out there?
I'm not certain that it is something that's going to be, if it's rigid, that it would be extremely helpful. And the only reason I say that is because if it's a review every 10 years and if that's the standard that is assigned, and if the concerns don't arise in year 1 through 10 and they arise in year 11 or year 12, then you're going to be no more swift in addressing the issue or the concern that's arisen than you would be if there was no standard for review. So I think there's pros and there's cons to trying to set something that's rigid. I think we're trying to drive a culture change that, but need the flexibility to be able to do that internally, and the flexibility to try to balance the resources, the resource concerns, the statutory mandates, the court-ordered regulations that we're required to. And we're just pushing retrospective review as a priority, so it's on equal footing with the other priorities.
And I agree, and I think we agree on that. Retrospective review is one of those areas that you have to examine based on the cumulative process that's out there. Some regs that have been there for decades may be very necessary decades ago, but now technology has increased, state enforcement has increased. That industry has dramatically moved past that, and it's not as much of an issue, yet they're still sitting with the paperwork requirements and burdens and measurement requirements and everything else. You mentioned a couple times the cultural change on it. This is one of the things that if I get anything from people at home, it's not that they're opposed to government. I really don't get that. And I think there's a misnomer that people say they call it because they're mad they don't want government. I just don't hear that. They want a government that they know is there to serve them. It is the attitude of the regulator. It is the attitude of the compliance person that comes. I walked into a business not long ago that said to me directly, OSHA used to come, and when they came, they walked around the facility and they said, hey, that needs to change, that needs to change. And they were extremely helpful. Now they walk in and say, there's a fine for that, there's a fine for that, there's a fine for that. First time I've heard about it. And it seemed like there was a completely different issue. And with that particular person that walked through the door, the attitude was not to serve, the attitude was to fine. Now, is that every person at OSHA? No, I don't believe it is. But they immediately walked away saying, my government is opposed to me rather than helpful to me. Now, I don't hear that from Secretary Perez, but I would say that cultural issue is very important. Let me just run down a couple things that I've heard just recently on it. I talked to someone recently that turned in a form that was 73 pages long of zeros. Page after page, they had to go in and fill in the blank to do zero because they had nothing to report. I had another person in my state that didn't turn in a form saying they had nothing to turn in. They faced $1 million fine for not turning in a form saying they had nothing to turn in. I have another business, completely different agency on it, that didn't turn in a form, was in full compliance, but didn't even know about the form, didn't know it was needed, was in compliance if they had have turned the form in, and they were fined $840,000 for not turning in a form, though they were in compliance if the form was turned in. But simply the piece of paperwork, they're now facing all this arbitration and trying to go through this process to not have to pay an $840,000 fine. I had one of the folks I talked to in my state recently was so upset at the regulator, and the person they were interacting with asked a simple question: I want to talk to your manager. And it was a simple, straightforward question. They were told no, and they said, how do I get it? And the response was, make a FOIA request, which they did, and it took 6 months to get the name of the manager of this individual so they could contact the name of the manager. That is not service. Now, again, this hearing is not about that, but it's part of the retrospective review process for agencies and for all the folks at this dais to know we really do still work for the American people, and everything they would do dealing with safety and with health, all those things are to serve. And at the moment that our forms and our processes appear that the American people work for the federal government rather than the federal government works for the American people, it's on its head. And so part of our challenge is, how do we constantly go back and look at these things and have a regular process to make sure that we're not treating the American people like they work for the federal government when it is the reverse? And so I think that's some of the passion. I don't mean to speak for both of us on it, but I think it's some of the passion because, again, I don't hear people anti-government. They just want to know, how do I make this work more efficiently so I actually work for my employees and my family rather than having to turn in constant forms?
Well, and I think they're pro-common sense. I think most people can say, look, do we want safe food? Absolutely. Do we want to be able to track when there's an E. coli breakout? You bet. Do we want to make sure that we don't have human slavery and that people are getting paid what they're required to get paid under federal law? You bet. Do we want the tribes to have access to systems and rights of way so that they can not flare their important natural gas? Yeah. I mean, and so all of these regulations are critically important, or we wouldn't be here. And many of the regulations that you all have promulgated, we've mandated. I mean, that's the dirty little secret here, is that we blame the regulator, but a lot of what the regulation is basically trying to be in compliance with our laws. I have an issue that I want to raise.